and welcome to ProfDale's Property Video number 40. I'm your host, Dale Whitman. In this video, we're going to talk about remedies that the courts will give to a party who experiences a breach of a contract for the sale of real property. In other words, remedies for breach. We need to understand that before any party can recover for a breach of a real estate sale contract, the non-breaching party, the innocent party, must first tender his or her own performance. The reason that tender is necessary is that the performances of the parties under a real estate sale contract are considered concurrent conditions. What that means is that in a real estate sale, the purchaser's tender of performance is a condition of the vendor's duty to perform, and likewise the other way around. The vendor's tender of performance is a condition of the purchaser's duty to perform. So what that means is that neither party is in breach unless and until the other party tenders his or her performance. We refer to these as concurrent conditions because each party's tender of performance is a condition of the other party's duty to perform. Now, what constitutes a tender? Well, the most obvious thing to do would be, if you're the purchaser, show up at the scheduled closing and have a cashier's check or a wire transfer to pay the money that you're obligated to pay under the contract. If you're the vendor, you'd show up at the scheduled closing with an executed deed ready to deliver it to the purchaser if the purchaser tenders the money. So those are the obvious examples of a tender, but most courts are not quite that persnickety about it. Most courts would say if you make an offer to perform immediately, and that offer is coupled with a present ability to perform, you have tendered. So you don't literally have to present the check or present the deed in order to say that you've tendered your performance. Don't forget to tender. It's not unusual for parties to sue for breach of a real estate sale contract and then to discover that they've never made a tender. And without a tender, you simply can't get a remedy for the other side's breach. There are a few situations in which a tender isn't necessary. The first one is tender isn't necessary if the other party has anticipatorily breached the contract. For example, if one party sends a letter to the other saying they're canceling the contract, indicating they simply have no intention of performing, then the innocent party isn't required to tender. Second, if one of the parties is obstructing the tender, you can't find them, you can't contact them, you don't have any way of expressing to them your present willingness to perform the contract. If that's the case, then you're excused from having to tender. Finally, you don't have to tender if the other party's performance has become impossible. For example, if the case is that the vendor has already sold the property to somebody else, and they can't possibly sell the property to the purchaser under this contract. And that means the purchaser doesn't need to tender in order to sue for breach of that contract. Now we're ready to talk about the standard remedies for breach of a real estate sale contract. And traditionally there are three standard remedies. The first one is damages, money damages. They could be actual damages or they could be liquidated damages. Either way, the money is intended to compensate the non-breaching party for the losses that they experience as a result of the breach. The second standard remedy is specific performance. That's a case in which the court actually orders the breaching party to perform the contract, and if they refuse to do so, they'd be in contempt of court. The third remedy is rescission and restitution, and that's a case in which the parties are placed back in their original positions. That means that the contract is essentially unwound and terminated. If the purchaser gave some earnest money when they entered into the contract, the earnest money is returned to the purchaser and everybody is back where they started. Now, these are the standard remedies, and all three of them are available to either party if the other party breaches. Well, let's start with the first remedy, damages. How do we measure the damages that the non-breaching party is entitled to? The standard measure of damages for a breached real estate sale contract, we call them expectation damages or sometimes loss of bargain damages. They're measured by the difference between the contract price and the market value of the property on the date of the breach. Now, who has damages? If we assume that the contract price is a fair estimate of the property's value at the time the contract is signed, and let's assume that it is, then if the value drops before the breach, the vendor will have damages. And that makes sense because the vendor has to put the property back on the market now, and it's going to sell for a lower price if prices have been dropping. On the other hand, if the value rises between the time the contract is entered into and the time of the breach, the purchaser will have damages. Why? Because now the purchaser has to go back into the market and buy other real estate, and that other real estate will have a higher price because prices have been rising. Now you can see that under the standard measure of damages, that is the difference between the contract price and the market value on the date of breach, we have to be able to measure the value of the property as of the date of the breach. How do we do that? Well, the standard way is to have an appraiser, or potentially more than one appraiser, come into court and testify about the property's value as it existed on the date of the breach. And appraisers are perfectly willing to do that. Sometimes, however, a court will bypass the necessity of bringing appraisal testimony in by saying, if the property has been resold at an arm's length sale reasonably soon after the breach, we can simply take the resale price as it actually existed and equate that to the value of the property on the date of breach. Obviously, that's only an approximation. It may not be very accurate, but if the resale occurred quite quickly after the breach, many courts are willing to do that. We're going to do an example of the damages remedy, but before we do, it's useful to look at the path of U.S. housing prices going back to the 1980s and up to the present time. What we see is a gradual increase that went faster and faster through the early 2000s, and then beginning about the middle of 2007, we see a major price decline that bottomed out about 2012, and then generally a rising pattern thereafter. The point of this example is that housing prices and real estate prices in general can go both up and down. For a long time in the 1980s and 90s and early 2000s, people simply assumed that real estate would always go up in price, but that's simply not true. Prices can move in either direction. Now let's see how the measure of damages for a breach of a real estate sale contract would work in a falling market, such as the one we had between about 2007 and 2012. Let's assume the following facts. The contract price for this real estate is $250,000. Earnest money of $2,500 is paid, and then the purchaser breaches the contract. The vendor, let us assume, sues for expectation damages. The fair market value at the time of the breach has declined, and it's only $225,000. That's a falling market, as you can see. So the damages that the vendor will experience based on the standard measure, the difference between the contract price and the market value on the date of breach, is $25,000. Let's assume that the property doesn't sell when it's put back on the market and the price continues to drop. And again, that was true in much of the U.S. between 2007 and 2012. At the time of the trial, the property's value has dropped more. It finally drops to $210,000. And after that, 6 months after the trial, the property finally sells for $195,000. Is the vendor entitled to any additional damages because of the price decline either between the date of breach and the date of trial, or the further price decline after the date of trial? The answer is no. Damages are computed only as of the date of the breach, and anything that happens to the value of the property thereafter is the vendor's responsibility and risk. So this is one of the ways that we can see how the measure of damages that's based on the standard formula simply isn't an adequate way of really compensating vendors for their losses. It's one of the reasons that vendors very often seek specific performance rather than damages. Damages really is an inadequate remedy. Now, in addition to the standard remedy of expectation damages, vendors often claim additional damages for other things that happen because of the purchaser's breach. For example, are vendors entitled to recover the following as additional damages? The vendor may say, I should get a real estate commission as damages because I had to pay one on the second sale, and I'd already paid a commission on the first sale, the one that failed, so I'm out of pocket 2 commissions. And without the breach, I'd only have had to pay 1 commission, so I should get damages equal to the second commission that I paid. What about carrying costs of the property until it resells? For example, the vendor may have mortgage interest, they may have taxes, they may have insurance premiums, they have maintenance costs. All of these cost out-of-pocket money. Shouldn't I be able to get those as additional damages, the vendor may say. What about rent on the new property that I moved into until the old property was resold? I didn't expect to have to own 2 houses at the same time, but I did, and I ought to get the rent on the second one that I moved into as a measure of additional damages. Many courts, though not all, will deny recovery for these items, even though they are very real out-of-pocket costs to a vendor who experiences a breach. This is another reason that damages are often considered to be an unsatisfactory remedy for a vendor, and why vendors very frequently seek specific performance instead. The second remedy is specific performance, and the reason we give specific performance traditionally is that the remedy at law, in other words damages, is an inadequate remedy. So specific performance, the equitable remedy, is available instead if that's what the plaintiff wants. Now, when you're buying real estate, the remedy at law is certainly inadequate because every parcel of real estate is unique. No 2 parcels are in exactly the same location. None of them have exactly the same characteristics as any other parcel. And so, when a purchaser buys real estate, they can always get specific performance because they're getting the real estate itself, and a dollar amount simply isn't a substitute for that. However, can vendors also get specific performance? That rationale doesn't quite apply to them. They're only getting money when they sell the property, and money, while it's nice to have, isn't unique at all. So why is it that vendors can get specific performance? Well, one silly reason that the courts sometimes give is mutuality of remedy. That is, if one party can get a remedy, the other party ought to be able to get the same remedy. That's a completely unsatisfying rationale. A better rationale recognizes the fact that real estate is illiquid. When you put real estate on the market, depending on market conditions, it can take a long time to sell it. So if the vendor recovers damages, and that's the vendor's only remedy, the vendor is left with the risk of attempting to resell the property. And nobody knows how long that will take or what kinds of additional losses the vendor might experience in waiting to sell the property. So because of this risk, a risk that the vendor bargained to get rid of in the original contract, because of this risk, the courts give the vendor specific performance instead. Specific performance eliminates the risk of having to resell the property. It gives the vendor the full benefit of the original contract. It allows them to get rid of the real estate right now and get the price they agreed to receive. So the bottom line is either party can get specific performance. We've already indicated that in general, specific performance is available to both purchasers and vendors. However, there are a few situations in which a court will not give a remedy of specific performance, even though it might give damages. For example, if the contract is considered to be vague, so vague that the court feels it's unfair to give specific performance, it might give damages instead. Second, if the contract is unconscionable, that is, it's very, very harsh on the breaching party. Even if the court would award damages against the breaching party, the court may refuse to give specific performance if it considers the contract unconscionable. What if the vendor is the party against whom specific performance is being sought, but the vendor literally just doesn't own the land anymore? They've already sold it to somebody else, a bona fide purchaser. The court won't take the title away from the bona fide purchaser, and therefore the vendor literally cannot comply with the contract. So the court won't give specific performance against the vendor in that situation. For other reasons, performance by a party may have become impossible. For example, the vendor may own the property, but it may have title defects on it that are incurable. They can't be fixed, and therefore the vendor cannot convey a marketable title. On the purchaser's side, sometimes the purchaser literally just does not have the money to complete the purchase, and they also can't qualify for a mortgage loan to borrow the money to complete the purchase. So in both of these situations, performance is literally impossible, and the court will not order specific performance. Sometimes the purchaser is a flipper. They were buying the land, but they already had a contract to resell it to somebody else at a profit. In that situation, the courts usually will not give specific performance because it's very easy to measure the damages with a high degree of accuracy by looking at the profit that the purchaser was going to make. Finally, the contract itself may exclude the remedy of specific performance. It's perfectly permissible in a contract to spell out which remedies will and which remedies will not be available in the event of a breach. And sometimes the contract will simply say that specific performance for one party or the other, or sometimes both parties, is simply not available. Now let's think a little about liquidated damages clauses. Some basic questions. Purchasers, of course, nearly always give earnest money when they sign a contract. In some areas of the country, the earnest money is typically 10% of the purchase price. In other areas, it's much less, but it's always a significant amount of money. Purchasers are also usually obligated by a liquidated damage clause in the contract. Does the amount of liquidated damages have to be the same as the earnest money? The answer is no, it doesn't have to be, but nearly always it is. That is, the clause will say the purchaser gives X amount of money as liquidated damages and as earnest money. It's entirely possible for a liquidated damage clause to have a different amount than the amount of earnest money, but it isn't very common for that to be true. Now, why do parties put liquidated damages clauses in real estate sale contracts? What's the point? Well, obviously for both parties, putting in a liquidated damage clause eliminates the risk of litigating about the amount of the actual damages. Remember, actual damages depend on the difference between the contract price and the market value on the date of breach. And the market value on the date of breach is subject to considerable disagreement, perhaps to appraisal testimony. Nobody knows how that will come out. Well, a liquidated damage clause simply eliminates the risk of litigating about that entirely. Second, from the purchaser's point of view, a liquidated damage clause puts a cap on the purchaser's financial exposure. In effect, the purchaser is saying, well, if I breach, I could lose this amount, but at least I know I won't lose any more than this amount. Finally, if we think of it from the purchaser's point of view, a liquidated damage clause is a lot like buying liability insurance. In effect, the clause says the limit of your liability will be this amount, no matter if the actual liability you have is much greater than that. So it is like buying insurance. You probably know from studying contract law that the courts distinguish between a valid liquidated damage clause and an invalid clause that imposes a penalty. So what's the test for a valid liquidated damage clause? Well, the first test is that the amount fixed in the clause has to be a reasonable advance estimate of likely damages viewed as of the time the contract is entered into. The second test is that the actual damages would be uncertain in amount and difficult to prove. Now, these tests really are inconsistent in the sense that if the damages would be uncertain and difficult to prove, almost any estimate of future damages might be considered reasonable. And in fact, when we look at the real estate market and recognize that it may fluctuate either upward or downward, and we don't know how much in advance, that it will fluctuate, almost any amount that's fixed could be considered reasonable. Recent economic history between 2007 and 2012 provides an argument for upholding larger liquidated sums because the fluctuations in value were so extreme. This distinction between a valid liquidated damage clause and an invalid penalty means that it's possible to argue that the earnest money clause is an unreasonable liquidation of damages and therefore should be set aside by the courts. Who tries to argue that? Usually it's the purchaser. and the purchaser usually argues that the liquidated sum is unreasonably big in order that they can have the court set it aside, give them back their money, and they only have to pay actual damages. In reality, courts routinely uphold amounts up to 10% of the price or more as being reasonable. Sometimes they'll go as high as 15 or even 20% of the price. But below 10%, it's a slam dunk that a court will find that the liquidated sum is a reasonable amount. Sometimes the person arguing that the liquidated sum is unreasonable is the vendor, and the vendor's argument is that the liquidated amount is unreasonably small, and they argue that so they can get the court to set it aside as unenforceable, and they can get bigger actual damages instead. Vendors almost always lose that argument. Courts rarely adopt it. The reasoning is typically that the clause was put in to protect the vendor, the amount was selected by the vendor, or at least agreed to by the vendor, and the vendor has to stick with that amount. It won't be considered unreasonably small. Now, normally, if a contract has a valid liquidated damage clause in it, can the vendor ignore the clause and seek actual damages instead, typically because they're a bigger amount? Well, the answer is obviously no. That's the whole point of the liquidated damage clause, is to cap the purchaser's liability at the liquidated sum. What about the vendor who, instead of actual damages, seeks specific performance? Well, the answer to that is clearly yes. And the reasoning is that specific performance isn't a form of damages at all. It's carrying out the contract, not getting damages for breach. And therefore, the liquidated amount and the liquidated damage clause have no bearing on the ability of the vendor to get specific performance. What if the contract has a clause in it that seems to give the vendor the choice of actual or liquidated damages? Here's a clause. If the purchaser breaches, the vendor may elect to terminate the contract and retain the earnest money as liquidated damages, or sue the purchaser and recover actual damages, or enforce specific performance by the purchaser. There's no problem with C, enforcing specific performance. That's certainly going to be allowed. But should a vendor be permitted to elect between the liquidated sum and actual damages? Should a court allow recovery of actual damages under this language? Well, the answer is it seems like giving the vendor the opportunity to have his cake and eat it too. In effect, what it would be saying is that the vendor can keep the liquidated amount if the actual damages are lower, but can go after actual damages if they're higher. Well, that seems like a fundamental undercutting of the basic concept of a liquidated damage clause. The courts are split on this issue, but I would say that probably a slight majority of them do allow this sort of election of remedies clause if it's spelled out specifically in the contract. I personally think this is wrong, but it has become quite common for courts to allow it. Another issue that frequently comes before the courts is whether the vendor should be permitted to retain the deposit as liquidated damages if the vendor has no actual damages at all. For example, suppose the vendor places the property back on the market after the purchaser breaches the contract, and it turns out that the property sells for more than the original contract price. So obviously the vendor has no actual damages. Can the vendor still keep the deposit? The logical answer is yes. Here's what the vendor might do. They might send a note to the purchaser saying something like this: "Thank you very much for breaching the contract. I made out like a bandit. P.S. I'm keeping your earnest money." Logically, that's okay, because after all, if we think of the liquidated damage clause as a form of insurance for the purchaser has gained the value of the insurance by capping the maximum amount of damages. It's a little bit like saying if you buy insurance on your car and you don't have an accident, shouldn't you be able to get your insurance premiums back? And the answer, of course, is no. You bought the insurance, you got the benefit of it, you can't complain about the fact that your premium is now out of your pocket. So logically, economists almost always argue the vendor should be allowed to do that. Nevertheless, some courts have found it just a little too much to swallow. It seems too much like unjust enrichment of the vendor, and so the courts are split as to whether the vendor should be allowed to keep the earnest money if there are no actual damages at all. Now suppose there's no liquidated damage clause in the contract at all. Earnest money is paid, but nothing in the contract says anything about it being considered liquidated damages. Can the vendor still keep the earnest money if the purchaser breaches? Well, the answer in most courts is no. The vendor can retain only the amount that's equal to the actual damages, if indeed there are any actual damages, and would have to give restitution of the rest of the money to the purchaser. On the other hand, there are a few courts, including both New York and Illinois, that hold that the vendor can retain the entire deposit. The basis for this holding is that the purchaser who breaches has unclean hands and therefore cannot assert the equitable claim for restitution of the rest of the earnest money. I personally think that's rather screwy reasoning, but it is what they hold in those few states. And by the way, in those states, the so-called penalty limitation on liquidated damages doesn't apply because these are not considered liquidated damages. And therefore, in those states, sometimes vendors get to retain very, very large sums of earnest money and far in excess of what would be permitted if we applied the 10% or so limitation that's common on a penalty in states that do consider liquidated damage clauses. By the way, for this reason, some writers have asserted that in states like New York, it actually makes sense for a vendor not to include any mention of liquidated damages, because that may actually limit how much in the form of damages they can retain, whereas if without the clause, they can keep the entire earnest money. Now here's one final issue to consider. Can the purchaser's remedies be limited? We've already said that in general, the courts allow language in the contract to state which remedies will be available and which remedies won't be available to each party. Suppose, however, we have an extremely severe limitation of the purchaser's remedies in the contract, one that looks like this. In the event of a breach by the vendor, the purchaser's sole remedy shall be rescission of this contract and a return of the purchaser's earnest money. When would a developer want to employ language like this? Well, this sort of language was employed back in the 1990s by a number of condominium developers in Florida and other East Coast states when prices were rising very rapidly, and they anticipated that even though they might pre-sell a unit to a purchaser at a given price, by the time the condo project was completed and the units were actually available for occupancy, prices would have risen and they might be able to resell that same unit to somebody else for more. So they would put this clause in the contract in order to anticipate that if prices went up a lot, they would simply tell this purchaser, go away and don't bother me anymore. Here's your earnest money back. I can sell to somebody else at a higher price. Now this seems quite unfair to the original purchaser because as a practical matter, the rescission remedy isn't much of a remedy at all. Should a court enforce this sort of language? Well, the courts in Florida struggled with it and ultimately decided that that kind of language was not enforceable and that the purchaser would have the normal remedies of damages or specific performance in spite of this language that seemed to limit the purchaser to rescission alone. Otherwise, the court said, the contract really would become illusory. It really isn't much of a contract at all. It doesn't really give the purchaser any rights, and that's simply contrary to the normal expectations that purchasers have. That completes video number 40 about remedies for breach of real estate sale contracts. In our next video, number 41, we'll cover the doctrine of equitable conversion and see how it affects enforcement of contracts. If you have questions or comments, email ProfDale01@gmail.com. Thanks for watching.